act often within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Thank you, Ronnie. Good morning. Welcome to the Massachusetts Appeals Court. My name is Judge Desmond. To my right is Justice Ditkoff. To my left is Justice Englander. We'll be your panel for the two cases that we have to hear this morning here in the courtroom. We 15 minutes per side, no rebuttal. We've read your materials and are familiar with the cases, so you need not recite that, but of course your 15 minutes is yours to do with what you will. With that, we'll hear the second case on our list this morning. It's docket 24P0453, the Commonwealth versus Charles Jenkins. Attorney Rose.
Good morning, and may it please the court. My name is Rachel Rose, and I'm representing Charles Jenkins, who is present here with us today. Mr. Jenkins only had one life to spend in prison for the death of Anthony Graves. If he served his life sentence after an unfair trial, any interest the Commonwealth has in retrying him pales in comparison to this court's interest in finally righting that wrong. A trial judge is supposed to bear some responsibility for selecting jurors who are capable of giving the defendant a fair trial, which includes presuming his innocence while they're hearing the evidence and holding the prosecution to its burden of proof beyond a reasonable doubt. We have a spate of decisions and a state statute, all saying it's not enough to just assume everyone who shows up for jury duty is on board with these concepts. A jury full of people who don't believe in due process aren't going to produce a constitutionally adequate verdict, whatever they're instructed. So the trial judge has to ask the veneer something at least intended to keep those people out. That wasn't done here. The trial judge denied Jenkins's motion for individual voir dire and rushed through picking a jury for his murder trial after just a few questions administered to all of them at once. Asking if they've even vaguely heard of American due process standards doesn't tell the potential jurors that they're bound by them or ask whether they intend to follow them. There's a big difference between what it means to be aware of something and what it means to understand, accept, or agree to it, because only the latter tells you anything about the person's own views on the subject. There's no other time they were asked. The judge's catch-all question at the end did nothing to fix it, because you can throw the presumption of innocence out the window or decide guilt based on only a scintilla of evidence and still say that you've done it.
Counsel, what do you rely on for the proposition that at the time of the trial, 1989, the jury needed to be asked whether they agreed to these principles?
The statute was unchanged at that time. It still had the same formulation, and the cases I rely on, at least some of them,
The statute used the word understand.
It uses the word understand.
So but you go one step further. You say that the jury had to be asked and confirm that they agreed with the principles, that they would follow the principles.
That is what the defense asked for, and actually it's the Commonwealth's case that they cited, and that says that if you ask for these questions, they're supposed to give them. So that is error, that it was objected to and he didn't give them, and that law has not changed since today.
The law existed in 1989.
It did.
And it existed at the time of his first direct appeal, correct?
It did.
Okay, so why wasn't it raised then?
I can't answer that question.
Well, the statute says there has to be questions designed to learn whether such juror understands the defendant is presumed innocent. Why aren't these questions designed for that? Seems like the only purpose they have.
So the design is different if you're asking someone whether you're aware of something versus whether you understand something. If you understand something, it has at least the implication that you agree to it, that you know that this is what you're doing.
But the statute doesn't say you have to ask people whether they understand or whether they agree. It says you just have to have questions designed to learn whether the juror understands. Aren't these questions designed to do that?
Well, you can answer either yes or no to whether you are aware of something, and it doesn't tell you anything about whether you understand it. We had a member of Congress the other day saying if you broke the law, you shouldn't get due process. Obviously, they don't understand anything about it, and they should never be on a jury. But they would have not raised their hand for that question. They would be on that jury.
So, Counselor, you keep citing Chapter 234, but my understanding is that 234A is what applied in Suffolk County in 1989. Is that wrong?
I'm sure you're right, Judge.
All right, so under Chapter 234A, Section 74, you can't reverse unless the objection's been made as soon as possible and the defendant has been specially injured or prejudiced thereby. So I'd like your best argument, one, that he objected as soon as possible, and two, that your client was specially injured or prejudiced.
My understanding is that it's or. They have to either object.
Well, under 234, Chapter 234, that's what it says, but under 234A, 74, it says and. Well, anyhow, either way, give me your best argument on those two.
Specially injured. The second objection the next morning after a juror comes up and he's comfortable telling the court officer and then again to the judge, I thought he was guilty as soon as I saw him. That should be a sign that he was injured by this question, that if that juror didn't think that they should have raised their hand for that, then there probably were others who slipped by. You can also point to how difficult they found their deliberations.
Sorry, what are you referring to? Something that's in the record indicating that a
Yes,
juror
in the
who
record.
actually said that?
No, he did not sit. They removed him after he said that he made a passing remark to a court officer, and the judge declined to ask whether he declined to pull the rest of the jury and ask whether he'd said it to any of them. But he was comfortable coming up there and saying, "Oh yes, I thought it was fine that I thought he was guilty the moment I saw him." There's a not insignificant possibility that others might have felt, well, that they took the judge's comments, and they took the judge's question and ran with it, that yes, I'm aware of those things, and I'll keep them in mind, but I
That's
don't
not the
necessarily
only
agree
thing
with
he
them.
said. I mean, in the paragraph above, he begins by saying, ladies and gentlemen of the venire, there are certain principles of law that apply to all criminal cases. So, taking that with the next sentence, he's saying, these things you're aware of, they apply. Right?
He does say that they apply to the case.
In any other area of the law, we presume that the jury will follow what the judge says the law is. And for some reason, in this area, you say the law should be that they have to be asked whether they agree. And that goes back to my first question, which is, in 1989, you're saying there was law that said they have to be asked whether they agree with these principles? What case are we citing for that?
My sister may have the earlier version of the statute, but my research of it was unchanged since long before his trial.
The statute uses the word, I'm sorry, go ahead.
If they're willing to apply it, does it matter whether they agree with it or not?
Willing to apply it is the same question, but that was never asked of the jury.
My question is not the same question. My question, you say they had to agree. Do I understand you correctly?
Are you asking whether, so the minimum, our position is that the minimum requirement for voir dire is that you ask the jury something that their answer will tell you whether or not they're going to understand and apply those due process principles, not just that they know they exist.
Okay, so you're not pointing to any specific language.
There's no specific wording that's required. The test should be, and from the existing case law, I believe is, that if the answer to your question doesn't tell you anything, the answer to that question doesn't tell you anything about the person's views on the presumption of innocence, it doesn't tell you whether they understand it or agree to it, it just says, do you know that it's there? Because you can know that it's there and not agree with it at all. You have to ask a question where the answer will differ based on whether you're going to understand and apply those principles. Let me continue. So under any standard of review, our position is that impaneling a jury who hasn't agreed to what it means to be impartial should end the inquiry because it fails the most basic standards of due process. But the rest of his trial went no better. This was a crime of and between young black people in Mattapan in the 80s and under almost complete culture of silence. The case against Jenkins depended on a little bit of eyewitness testimony, pulled from among the crowd of dozens of silent witnesses who refused to cooperate with police. The incredibly deep stab wound was the only physical evidence. An 8-inch blade is almost a sword. Lots of the other people there had to have seen what happened from close up, but no one talked.
This is his third appeal, is that correct?
This is his third motion for a new trial.
His convictions have been affirmed twice previously?
It has. These particular errors were never raised, though.
Why not?
I'm afraid I can't answer that question either. Our position is that it's ineffectiveness not to raise these issues because they jump out from the transcript and they're very serious.
So the first two motions for new trial looked like they were sort of bulleted with one particular issue. Was he represented by counsel?
He was represented by counsel. Both were.
The first one had to do with seeking a reduction to manslaughter, correct?
That's correct.
Second one,
Courtroom closure.
courtroom closure with respect to his brother?
Yeah, his brother and his mother. So in terms of what kind of...
What do you do with the, I mean, we have cases that say you're supposed to, if you're going to take a motion for new trial, you're supposed to raise all your issues at that time. He's represented by counsel, he didn't raise this issue. It is waived. Does that mean, I guess we still have to do substantial error review at that point?
That is the law, that it is still, it's still evaluated for substantial risk of the miscarriage of justice. There's nothing saying that you can't put it together with the other errors that have already been pointed out in this case. You can look at all of these in concert, especially in conjunction with these issues that were previously raised. You could look, the likelihood of this trial actually producing a fair and constitutionally valid guilty verdict is fairly remote. It's the closing argument. We have some law in the closing argument that says that what the prosecutor was doing is improper. He was expanding the definition of evidence to cover his own theories, as opposed, and saying that that is actually the evidence that you should use to make these decisions, were his theories that were not actually based on any of the evidence at trial. They were just based on how he thought they should have gone, and that's...
What are you referring to specifically with respect to what the prosecutor said?
So the spectator part,
Well, you say that he's expanding on the evidence in a way that is not supported by, you're saying basically not a reasonable inference to be drawn, right?
it's not a reasonable inference.
What is it that he said that you say fits that category?
Well, there are several parts that are objectionable, certainly as to the spectators when he's asking the jurors to ask yourselves, try to remember when, who was in the spectator benches when at different points in her testimony. They wouldn't know. No one knows who
I thought there was
people...
testimony about that. Didn't she testify about the brother being there and then that he wasn't there?
She did not. Not the part that we pointed out. The prosecutor pointed out two people.
Section page 66 of the second volume, doesn't she testify she sees the defendant's brother in the courtroom? And then later she was talking to witnesses just 5 minutes ago, on page 83 of the transcript?
So my sister and I both thought that the closing argument was not referring to the brother, as it's an implication that she's being threatened or intimidated into testifying, and that wouldn't be coming from a 6-year-old. But so we both...
Why isn't it the brother? The brother's the person she says is there, and then they kick him out of the courtroom.
He was 6. He wouldn't be intimidating her.
Brother was 6?
117, 118 is the exchange that we
The brother was
both
6
thought.
year old at the time. That's what you're saying.
That is my understanding from my client, that
But why was he under sequestration order then? He was going to be a witness at 6?
he's not a witness. No one knew anything.
So you say it's improper for the prosecutor to ask the jurors to take note of how the witness was testifying when there were certain people in the courtroom?
Well, so
Why is that improper?
So he's implying that the two who left were friends of Jenkins there to intimidate her into changing her testimony.
The question is, did he testify, or was the testimony different when there were different people in the courtroom?
And how would the jury know that? They're looking at the witness, they're not looking behind them.
The jurors are in the courtroom and they're paying attention to the witness testifying. I mean, he's not saying they have to do that, right? The prosecutor wasn't suggesting that they had to do that.
Our position is that the argument struck to the core of his defense by telling them that he knew who was being intimidated, even as the witnesses were up there on the stand denying it. She's saying, I'm not being intimidated by his friends. And he said, well, she says that, but you shouldn't believe her because of something
He
that
can
the jury
make
would
that
have
argument.
no way
He's
of-
free to make that argument. She changed her testimony from the time she was before the grand jury, right? So he's free to make the argument, why did he change his testimony? And then the jury, following on Justice Desmond's question, and it is interesting, right? It's not in the record, but it's happening in front of the juror's eyes. Okay, why can't the prosecutor make an argument about what's happening in front of the juror's eyes? I mean, if they disagree with him, that's of course their right. The judge is going to tell them that they can disagree with him.
So they actually got less than the usual instructions as to the closing argument. And this also applies to the other two parts of the argument that we took issue with was the knee wound. There's no grounding in the testimony for where that came from. But what the jury...
I didn't hear what you said, I'm sorry.
So as to the knee wound, the prosecutor argued that it proved that he intended to murder him because he moved the knife from the knee to the chest, but no one knows exactly when those two wounds were inflicted. And this is the same sort of issue. But the instructions the jury got before the closing arguments, but not after, they got the instruction that it's their memory of the evidence that matters, but the judge also told them directly that counsel will not intentionally misstate the evidence. So the worry is that the prosecutor would take the prosecutor's comments and run with them, saying he was trying to tip them off that he knew the witness was being intimidated, and that because he wouldn't intentionally misstate the evidence, there must have been something about the knee wound that they missed.
But he didn't make a statement about he didn't even say, this is what happened. He said, did you notice? Did she testify differently when different people were there? That's all he said, right?
He's very suggestive. Nothing actually happened, so he was not really referring to an incident. He's referring to an incident that he created by pointing them out. And I see I'm out of time. Thank you.
Thank you. Attorney Knight for the Commonwealth.
Good morning. May it please the court, Erin Knight on behalf of the Commonwealth, asking the court to affirm the defendant's conviction. Here, I just would like to also point out that the defendant had a direct appeal. It came through the appeals court and went on far up to the SJC. So in technicality, this is his fourth time before the appellate court. I would also...
I'm sorry, go ahead.
No, it's okay. I would also point out that the Commonwealth does consider these claims waived. Under our jurisprudence, he has had multiple times to raise these claims.
What does that mean? Does that mean we can't consider it?
It means that you don't have to consider it. I understand that this court can look at the record and
Is there a case that tells us, imagine my surprise when I first started doing this to find that nothing ever is waived in the criminal context. And this is the one area where we do say, no, you get, and I think the rule actually says that it needs to be raised one time, right? Do we have a case that says even though it's waived, you still must consider it for substantial risk of a miscarriage of justice?
I don't know of one off the top of my head that says even if it's waived, you have to consider it. I think it is the court's choice. I think where it has been raised, it is before the court. It's whether the court uses the doctrine of waiver to dispose of the issue. I think here the court absolutely can do that, as the motion judge found. I will state that the motion judge below also did consider the merits here, but did say that these claims were waived. I would also point to Commonwealth versus Francis, 485 Mass 86 at 106 and 107, where even though purported denial of an impartial jury may be considered structural error, with a time lapse of 30 some odd years, here 36 years, that can be deemed waived, and the court did go into that that analysis. So that may be helpful to the court.
I mean, why would we consider it waived? I mean, even if we could consider it waived, I mean, we're talking about kind of fundamental fairness and
Yes, Your Honor, and I do understand.
Crimes, so
Absolutely.
whether we had the option or not.
And that's why, we argue to the court below, and here on appeal also, we go into the merits as well.
All right, so
because
that being said,
yes.
can you pick up where your sister left off as to Was it improper for the government to point out the goings-ons in the courtroom while the witness was testifying?
Your Honor, I would say absolutely not. Here, the courtroom is where the trial is taking place. The jury is looking at the credibility of the witness, and that's not just her testimony or what's coming out of her mouth. That's how she's acting. That's how she looks. That's how she's presenting herself. And recognizing how that may change throughout the course of trial or throughout the course of her testimony is something the jury is looking for. Whether or not they knew exactly who was who in the in the gallery, or whether or not they noticed those things doesn't mean that there isn't an inference that somebody was there or they didn't take notice. That's something the prosecutor can point out, especially where here there was more than a reasonable inference of witness intimidation. In fact, the appeals court in their the first opinion on direct appeal stated as such that there was witness intimidation of Ms. Howard. And she herself testified that multiple people had told her not to testify, and that leading up to trial, I think days before trial, she was not planning to testify. And I think it also goes to the fact that the Commonwealth wanted to explain why Ms. Howard, who purportedly was the only one who saw the defendant pull the knife, stated that was the only one that saw him pull the knife out of the chest, not just with the knife afterwards, would change her testimony at trial from it being the defendant she saw to a man in a red shirt. So here, that's something the Commonwealth can try to explain to the jury and explain to the jury how they should view that evidence and why that evidence may have changed from grand jury to trial.
Is it true that Sean Jenkins was 6 years old?
That I don't know, Your Honor, and I apologize for that. That's not something that I remember from the record. I'm happy to look it up and submit a 16L, but that's not something that I considered in this analysis, because I think even despite...
I guess it's not very important, but if Willie Davis put a 6-year-old boy on his witness list and then Judge Mulligan kicked him out of the courtroom, that's weird.
It also may be that, this isn't the first time and speaking from personal experience, I have seen children in the courtroom. Often they are accompanied by an adult. So it might not just be the fact that a 6-year-old was sitting in the gallery by himself. Again, these are things that I don't believe are reflected from the record. But I guess if we're talking about reasonable inferences, I highly doubt a 6-year-old came by himself to court. In any event, even despite that section of the prosecutor's argument, again, this witness testified that she was being intimidated. Whether or not she considered it intimidation or wanted to speak to that day in front of the people that were there doesn't negate the fact that the evidence clearly showed that there was intimidation of Deborah Howard.
What do you say in response to the argument that asking the potential jurors whether or not they were aware of certain applicable principles was sufficient or not?
So we look at the instructions as a whole, whether it be the closing instructions or the beginning instructions to the entire venire. And I would say here, given the statute that it was under at the time, given the understand language, and given the fact that the defendant here, as seen under Figueroa, doesn't point to any injury other than he was convicted, that's an injury, you could say, in every case of a defendant being convicted. That's not a particularized injury pointing to the venire or the instructions to the venire. I would also state that it is still good.
Is that an element? Justice Ditkoff points out what the statute said at the time. Is that an element that would have to be shown, that there was material prejudice to the defendant from the way the questions were asked?
I would argue that I don't know if it's an element in terms of, when you look at an element of a crime, but I think it is something that in order to gain relief, in order to obtain relief, the defendant must show he was prejudiced by the error, if there was error. But there was no error here. When you look at the whole context of the entire instruction at the beginning, the judge talks about how these legal principles apply. He talks about how the nature of the case, the charge against the defendant, he inquired into any interest in the outcome, he inquired into the sensibility of bias or prejudice, and asked if they were aware and knew about these principles. The defense counsel's argument, or his, I guess, objection, if you wanted to call it that, was not to the structure of the nature of the questions, it was to the structure of the nature of the questions, not the actual definitions. He wanted it asked in the accept language. Do you accept? And you can see that in our appendix and in the defendant's appendix, the purported questions from defense counsel are in there. He wanted accept language. That wasn't the law at the time, and I don't believe it's still the law.
Not the law now, I hope.
Exactly. So, you look at it as context as a whole, and I think almost more importantly, the jury were properly instructed, and the defendant does not dispute, during its final charge, right before it was to make the decision. None of the jurors during venire that had raised their hands to any issue with those principles at the beginning were sat in this trial. So the jurors that were sat and the jurors that deliberated not only were aware of the principles, did understand that they apply, but then were instructed directly on those principles before rendering their verdict.
And so when he asked, were you aware of some of these principles, at different points in time, 5 jurors raised their hand that they might not have been aware, is that correct? In another instance, I think 11 jurors raised their hand.
Yes, and they were to different questions, but that's how we go through it. You know, we don't bunch it together and say, here are all the principles, do you understand? He went through and he delineated each one. He talked about the defendant doesn't have to testify. He talked about your biases and prejudice. And, you know, again.
No one raised their hand when he went through those, at least according to the record. He said that I see no response.
Correct, but he did ask them, and that's part of the overall view this court takes of the instructions as a whole. And I would also point out that this was like we've been talking about. This was 1989, and so you know the court has the statute was repealed, I believe. Or this version was repealed in 2016, but it hasn't changed much. And so the law of the Commonwealth still isn't.
So I'll ask you the same thing. Didn't 234A become applicable to Suffolk County in 1983?
Your Honor, I don't know that right off the top of my head, and I looked when Your Honor asked my sister that question. I don't know exactly the applicability to Suffolk County versus the Commonwealth as a whole, but I do know that under 234-28, he still has to show injury. The examination shall include questions designed to understand, and even past that, Figueroa case, which, is, it's in my brief, I'm sorry, I don't have the date right off the top of my head, but it does state that the jury has to be informed of the principles designed to determine if they understand, then has to show injury thereby. And
Figueroa was an Essex case under 234, right? Not 234A.
451 Mass.
yes, it is out of Essex. 234 and 234A, and I apologize again for not knowing 234A right off the top of my head, but my understanding, based on what Your Honor has said about 234A, is that if it includes, it's an and language, and it includes that injury language, so it would put us directly under the analysis that Figueroa did as well. So if that's the case, this defendant is still precluded by Figueroa because his case is much stronger than Figueroa here in terms of what the judge instructed to the venire and also what was given at the end. And as I said, the objection was to whether or not the jury accepted, not whether the jury understood. And so here, even under a substantial risk on any of the defendant's issues presented to this court today, there is no.
So I don't know that that's right. I mean, he specifically objects to the use of the word aware, okay? And the judge then says, well, what do you suggest I should do? And he says, well, what I put in my proposal. But I'm not sure that means that he didn't properly object to what was in fact said. So that the judge at that point needs to decide whether he's made an error of law that he needs to correct, even if the correction that's suggested is wrong. I mean, the way I understand the law, that objection is proper.
Okay, and that's fine, Your Honor.
See what I mean?
Yes, no, I do. I do understand that. I'm thinking, the way that how I'm structuring this is that the way that he objects isn't to the burden or the understanding of the jurors as a whole, is to the accept language. And if this court determines that that's not the case and believes that the objection stands, it's still not an error here where the totality of the circumstances totality of the instructions show that these were properly conveyed under the statute at the time. And in any event, the accept language, as we've spoken about, is not required. Here, there was no error made on his behalf, and if anything, the jury were instructed further before they deliberated. And if there are no further questions, the Commonwealth would rest on its brief.
Hearing none, the matter stands submitted.
Thank you.
Thank you both. We'll argue on both sides. Our third and final matter for the morning is 24P 0496, Nation Star Mortgage doing business as Mr. Cooper versus Richard Zulli and others.
You have both the benefit and the detriment of being alone.
Someone asked me if I get the appellee's 15 minutes as well. I'm like,
No.
I want to be out of here as soon as possible, take up as little of your time, so.
Let me help you with that question. No.
Good morning, Your Honors. Peter Gallardo on behalf of Nation Star Mortgage, the appellant. The appellee, Ms. Zulli, finished the case with a victory, and her attorney, Jason McGuire, who I believe is watching today, by the way.
I'm sorry, I missed what you said. Can you say that again, please?
Oh, I'm sorry. Ms. Zulli is self-represented, and there's no indication that she did not file a brief, and she's not going to appear today. I discussed this briefly with Attorney McGuire yesterday, who was her attorney in the housing court matter. He hadn't heard from her, and as far as I know, all he's doing right now is actually watching the case. So,
We'll hear you.
So, Your Honor, I'll try to be brief. The case really revolves around a limited point in the housing court, Judge Del Puerto's findings and rulings. Paragraph 9. This is a mortgage by husband and wife on a property. It had been modified 3 times, and then.
So at the end of the day, the husband's removed, right, from the loan documents, and it's just Ms. Zulli or Mrs. Zulli whose name stays on the modification. Is that fair to say?
Almost. He signed the 2014 documents, which is the same documents as the 2016. He signed.
Then why sign the 2016 document? What was the purpose of signing the 2016 document?
So there's no evidence in there, and then Judge Del Puerto conjectured that.
I'm asking you, what's the purpose of signing the 2016 document?
I don't know, Your Honor, but if I had to venture offer an explanation, it would be that the
You don't know?
maturity date.
Did you litigate the case?
It's document intensive, Your Honor. This came up.
But this is, look, you're here because this is actually much more complicated, at least to me, than it appears to be on the record, okay? And one of the questions would be the one that Judge Desmond just asked, which is if there's an ambiguity with respect to construing this contract, is there any parole evidence that would bear on it?
No.
And so my question is, really? You don't know?
Well,
no one's asked about the parole evidence? They don't know why that's there?
It's not in, there's nothing within the 4 corners of the record.
I understand it's not within the record. I understand it's not within the record. But Judge Desmond, I think, asked beyond the record. He said, what's the purpose of it? Do you know?
Maturity dates on this had been extended from 2033 to 2044. Mm-hmm. As the court knows, the obsolete mortgage would kick in 5 years after maturity date if that maturity date isn't updated on the records. The maturity date here.
That's terrifying. You thought that the foreclosure would take till 2038?
No, if the loan had been reinstated, Your Honor, and then kept going, and then if in 2038, for instance, the loan's still going, and then they go to foreclose or for other reasons, they go to refinance, they say, yep, I'm sorry, it's matured. So what they, in order to
Is she still in the house?
I believe so. The only communication I had with her is that she was preparing.
Was there another, I know these are outside the record, but these are relevant to whether the case is moot, hence my questions.
Did you request oral argument on this case?
I'm sorry, Your Honor?
Did you request oral argument on this case?
Here at appeal?
Yes.
Yes, we did, Your Honor.
Okay.
And the background behind that was we weren't really sure where the case was going, so at one point we requested an oral argument at my client's instructions, and that's why I'm here. But the point being
hold on. I'm sorry. I have some questions. So as far as you know, she's still in the house. My next question would be, and now I've forgotten it, darn it. Oh, go ahead, sorry. I'll remember it in a moment.
So we take issue with paragraph 9.
You were saying something about whether she was in the property? You had some kind of communication with her?
We exchanged an email a couple of months ago, and she indicated that she was preparing to vacate because I think in anticipation of the outcome of this case, she was preparing, but that's all that I've heard from her directly. Obviously, she was represented by counsel until he withdrew at the beginning of this case.
How would you characterize the 2016 document that she alone signed?
A re-execution of the 2014
And so why would you do that?
Again, we note in particularity that the 2014 agreement, which consisted of a loan agreement, a subordinated note, and a subordinated mortgage, was not recorded. That mortgage didn't make it to record, as did one of the prior modifications had made it to record. And again, I submit that the reason for going to record would have been to extend that maturity deadline.
Does it matter that Richard's name was on it in 2014, and yet he was not a signatory in 2016?
I think it matters that his name was on it in 2014 because he agreed to this. He signed it. He signed a new note.
So now that his name's not on it in 2016, does that make any difference? Does that have any bearing?
You know, practically, as I mentioned in the brief, Your Honor, that we don't know exactly why he wasn't on it, but the point being is that he already, in early 2014, he had deeded out his interest. They were in a divorce situation. Probably by 2016, for whatever reason, my client needed re-execution, i.e. for recording.
I'm curious why. That's an important point, don't you think?
I don't think it ultimately really matters, Your Honor. He's still obligated on the note. There was no striking of his name on the note. They may have been striking of his name on the 2016
He's
document.
also on the mortgage, right?
Well, he's still on the mortgage to the extent his interest was encumbered, but since he deeded his interest out in 2014, being on the mortgage or not, it's really nullity at this point. Her interest.
That's interesting.
Yeah.
Okay.
Her interest.
Because that's recorded. The fact that he no longer owns the property is recorded.
Yes, that was, I believe, in the spring of 2016. Now, he came back, obviously, in October. These are dated October 9th, but they're signed in November by the Zulis.
But the note is a negotiable instrument. You make this point in your...
Right.
And he's not been taken off the note, and the 2016 loan modification doesn't take him off the note. The note and his obligation to pay on the note remains.
There is no voluntary, objective action. There's no striking of his name. There's no agreement not to sue. There's no release of him in any of these documents. And so he's still on that. So, I mean, ask yourself, would Mr. Zulli, if an action was brought against him today, would Mr. Zulli be able to claim release? If someone sued him on that note, say the mortgage never foreclosed.
We asked the question. So my question was going to be, was another foreclosure instituted on this property after this?
No, this is the only one. It was completed in 2019, and we waited after COVID, and then the action was commenced. We had a hearing on summary judgment, which Judge Michamunova did a brilliant job sorting through the 25 affirmative defenses. He left the one question, and that was a question of fact for him, which was, should a new notice have gone out because did the 2016 mod
So
change?
your
You say
argument...
no to that. You say no to that. No new notice was required.
No, the 2014 mod happened. They immediately fell back into default. The 150-day notice and the 35-day.
Wait, you say back into default, and I think maybe you lose. They were in default.
They were in default, but
They
brought
made
out
no
of...
payments whatsoever in connection with 2016. There was no change at all to the agreement or with respect to what was owed.
What I referred to back into default, I meant after 2014. So they modified it in the fall of 2014, beginning of 2015. We see that in the loan history where the next due date is brought forward. Right? In 2016, they fell into default after the 2014 mod again. They were still into default into 2016. My client commenced service members action. They sent a 150-day notice in 2015. And then for some reason in the fall of 2016, the foreclosure was already undergoing. The service members action had been brought, judgment had been obtained. They asked for re-execution. Ms. Zulli alone re-executed it, and they took that, and then they did record the loan modification, and in preparing for this matter, they recorded a subordinate mortgage by Ms. Zulli, which again, she had all the interest in the property because Mr. Zulli had previously deeded all of his property, all of his interest in the property.
Oh, in 2000,
I'm sorry. So explain to me these two extra provisions in the 2016 agreement.
Paragraphs 8 and 9, Your Honor?
Yeah, why they don't matter.
Those are the only changes that I could find. I'm trying to find my copy, Your Honor. Those are the only changes that I could find.
Me too.
And one of them was just a warning saying you're still liable. And then the other one was a notice basically saying if, and there's no evidence of this if, that there's PMI is applicable to this loan, then that might change based upon the principal. Now, the principal actually went down.
Well, so let's start with 8. So in 8, she agrees for the first time that if your foreclosure is dismissed, she can't ask for attorney's fees. Why isn't that something?
Can I have a moment, Your Honor, please?
Yeah, it's at 219.
Sorry?
It's at 219 in the appendix, paragraph 8. Trying to find it.
So paragraph 8 provides notice and reaffirms pre-existing obligation. In the event of any actions arising out of or relating to this agreement, I will remain liable for and bear my own attorney's fees and costs incurred in connection with any such actions. There is a cost of collection provision anyways in the note in the mortgage, which allows my client to add cost of collection, foreclosure fees, attorney's fees to the debtor, to the balance of the note. So this isn't anything in addition. And then
Well, that's a change in the document, right? That's not
no
in the
change.
previous. Is that in the
Paragraph 8 was just a reminder.
2014? Is that in the 2014 document?
No, this is in the 2016.
Right, so it's a change from the 2014 document.
It's a change that didn't do anything. It's a notice.
Asked for it. Then why was it requested?
They used a slightly different form in 2016 than they had and there were 2 additional paragraphs. But these paragraphs don't add any burden. They're notices to her. They're saying you're still liable.
no, it's not what it says. It says, I will remain liable for and bear my own attorney's fees and costs. It's not a notice. Oh, you say it's a notice because she's already agreed to it? Is that what you're saying?
No, the remain means remain liable because she's already liable. That would be the, I can understand whether, Your Honor, is a little confused. The remain liable is because she's already liable on various terms in the note, including
But everyone
reasonable
starts
cost of
liable
collection.
for their own attorney's fees. That's sort of the natural state of life.
That's in
mean,
the mortgage and note.
Why shouldn't I interpret this as saying that she can't go after the bank for her attorney's fees?
For wrongful foreclosure, for example.
There's always that option, Your Honor, but this is,
Well, not anymore.
I mean, no.
Why isn't that consideration?
This, she's
I
always.
don't mean to be, I don't mean to
No,
be,
no, I understand the point. She's always been liable for not only the principal, the interest, the escrow, the attorney's fees, the reasonable cost of collections.
That's not what this says.
How could she be
This is her
any more
own
than-
attorney's fees. It
in the
doesn't say
event
anything
of
about
any
your attorney's
action
fees.
or in connection with any foreclosure action dismissed as a result of entering into this agreement, I will remain liable for and bear my own attorney's fees and costs. I.e., I'm giving up my right to seek those.
No, I believe the word remain, the modifier is, I'm not just newly liable, I'm remaining liable. I'm still on the hook as I was on the hook before. That's the way I would read it, Your Honor. I can't tell you how.
I don't understand why this wouldn't mean newly that if she had a 93A defense to the foreclosure, that she wouldn't be able to get attorney's fees. Whether that's enforceable or not, I don't know, but.
I'm speaking of the reasonable cost of collections of
I know you
attorney's
keep
fees.
saying that, but that's not what this says. It says my own attorney's fees. It doesn't say the bank's attorney's fees.
Well, bear my own attorney's fees and costs incurred in connection with any such action. Obviously, the rule under 93A and the fee switching is not, this private agreement is not going to override the consumer protection of 93A. 93A is always, and it's awardable. It's not just automatic, Your Honor. It's not always, it's awardable in case of a victory. It's not, I mean, she's already liable for her attorney's fees. She's already liable for my clients.
Absolutely.
And in the event that she wins and obtains attorney's fees, that's going to overrule any private writing.
If this agreement is ambiguous as to whether it reinstates the loan, why doesn't that just get decided against the drafter? If we can't figure out what this agreement is for and what it does, don't we have to construe it against the drafter?
That's ordinary rules of construction, Your Honor, but I see I'm out of time.
You can answer.
That's the ordinary rules of construction, if there is an ambiguity in the terms of the actual written terms. Now, there's been pointed to no actual ambiguity on the note. I mean, on the loan modification agreement within its four corners. It needs outside explanation.
I need to follow up on what Judge Didkoff asked. And it's the word reinstate. Does this agreement reinstate the loan?
The 2014 agreement reinstated the loan. This agreement just repeated what the 2014.
Okay, so how would one go about deciding that question, whether the loan is, quote, reinstated? And part of the reason that Judge Didkoff, I think, used the word reinstate, and the reason why my ears perked up is because the whole question here that the judge decided was that your client failed to follow the HUD regulation, which says if an account is reinstated and again becomes delinquent, the delinquency notice shall be sent to the mortgagor again. Right? So to me, there are two legal questions here, not really brief, not really addressed by the judge. First one is this a reinstatement? Second one is, if the HUD reg was not followed, is the remedy that the foreclosure is invalid? Do you have any views on either of those?
Well, as for the reinstatement, Your Honor, what was before the court and is before this court as well is the loan history. And the loan history demonstrates on, let's take a look on page 148. You'll see that under the 2012 modification, the due date, the next due date, this is on RA 148, moves from 5 of 09 to February of 2012. The same thing, because it's been reinstated. The same thing happens again in 2014, when if you look at page 134, the next due date column jumps from July of 2012.
And you say that we can infer from that it's a reinstatement, although, again, there's no evidence in the record about that, right?
An objective action of my client which indicates my client's intentions. Now, again, you know, as we said with Mr. Zulli, then you need an actual voluntary act, an intentional act, a meeting of the minds, if you will, Your Honor. My client's actions in changing the next due date in 2014 showed that this loan was reinstated. And then
Maybe I'm misunderstanding, but it seemed like you said this 2014 agreement reinstated the loan.
Right, and then in 2014...
And then I have this almost identical piece of paper in 2016, and this doesn't reinstate the loan. Why?
Because the loan had already been reinstated. So if you look forward again in the loan history, you get to 2016...
You can reinstate a loan as many times as you want, right?
Theoretically, yes, Your Honor, but there are no new terms, there are no new changes. This is an identical document, aside from those two additions. The same monthly payment, the same maturity date, the same interest rate, the same principal. Nothing changes. This is already the pre-existing rules.
Different signatory? Different signatures on the new document?
Ms. Zulli signed this one, and Mr. Zulli had previously signed the same exact material terms in 2014.
So the new one doesn't have Mr. Zulli signing it, right?
Right. Again, Mr. Zulli, they've already divorced.
We have two new provisions and one less signature, but yet your claim is it's the exact same document.
But what is the new consideration?
Those two new provisions.
As I say, one's a notice provision saying If there's PMI, then that might change. In this instance, there's no evidence in the record of PMI, and the principle dropped, which is what PMI is based upon. So any change that would have happened would have been positive. As for the first one, again, it was just simply reinstating that she remained, as she did before, liable for her own attorney's fees, subject to any finding under 93A, an award of attorney's fees, which would flip. This isn't going to stop a judge from, that paragraph 8 is not going to stop a judge from...
What is the structure under which the case comes to us? The judge has entered an order. Is that on summary judgment?
Summary judgment was entered by Judge Mitchell Munivar and then left one issue open.
Make an argument to the judge that he could not enter summary judgment in favor of the defendant because the 2016 loan modification agreement did not reinstate the loan, as that word is used in the HUD regs.
That was the argument made after Judge Mitchell Munivar granted partial summary judgment on all except, granted Nation Star partial summary judgment on all except that one issue. We submitted on the papers in lieu of trial, and now Judge Del Puerto reads the papers, and then on paragraph 9, he says it's a new agreement because...
Can you answer the question? Did you make the argument in a well, okay, so this is a trial, not summary judgment, right?
In the summary judgment, I made that argument, yes, I mean, not summary, in the documents in lieu of trial.
Documents in lieu of trial, you said we didn't have, this was not a reinstatement. The 2016 wasn't a reinstatement. We didn't have to give notice again.
Yes, that's essentially, that's the basis of it. Now, Judge Del Puerto the reason for said, oh, Mr. Zulli has been released, so therefore Ms. Zulli is greatly more impacted upon. Well, they were already joint and severally liable. So not only is there no evidence that Mr. Zulli was actually discharged, but even if he had been, she was already joint and severally liable. So there was nothing new placed upon her. There was no new obligations. And as for Mr. Zulli, there's nothing new that he hadn't agreed to in 2014.
What was the context in which the trial occurred? Was that like a stipulated that he only has to make limited findings under the rules?
We submitted on the paper, we agreed to submit in documents in lieu of trial. Again, this is all documentary. These foreclosures tend to be voluminous and documented.
Right, but this goes to our standard of review, because the question is, did he find that it was reinstated by the 2016 agreement? Did he make a finding on that?
Judge Del Puerto, in his findings and judgment, did make that finding, and then I asked for clarification as to why he thought Mr. Zulli had been discharged, and it's in there, number 83. It's in there in the addendum. He makes a finding in paragraph 4 and explains how Mr. Zulli was discharged and how this greatly impacted, but he doesn't elaborate. It greatly impacted Brenda Zulli, but he doesn't elaborate. So,
I'm assuming, and please correct me if you're wrong, that your problem here is that you didn't get possession, not that there's language here that might be a defense for Richard.
The Judge Del Puerto found against and found that we did not have a greater showing of right of possession. So,
but that's your concern. You won't be happy if we just say Richard is liable, but you got to do the foreclosure again.
That's what we're looking for: post foreclosure possession at this point. And then, as the court pointed out, the remedy for losing this case would be to recommence the foreclosure.
Did you make the argument to the judge that under the HUD regulation, that even if you had violated it by not giving notice, that that did not invalidate the foreclosure? Was that argument made?
I'm sorry.
In other words, the remedy for failure to follow the HUD regulation, which I believe the HUD regulation is incorporated into the contract.
It is, and the 150-day notice requirement at the time under 35A sort of was belt and suspenders, that the borrowers had to get some notice. And my client's position is the 2015 notice that it sent was in response to the failure, the falling into default after the 2014 mod had cured that default. And then in 2016, they didn't send a new one because this was just a re-execution. This is the course of the dealings of the parties.
I'm sorry?
This would have been the course of the dealings of the parties, that my client simply re-executed the 2014 mod. It has the same date on it, October 9th, 2014, and then obviously did not feel that that reinstated the loan, so didn't send another.
Where in the record are we going to find the parties' materials that will indicate what the process was that the judge was following before the judge entered his order here?
I have the docket somewhere in the.
Is it in the appendix?
The docket is in the appendix very early on. You're going to look at item 75 was the finding and judgment, and that was based upon the briefing in lieu of trial.
No, I understand. I've read his order. What I'm concerned about, in essence, you're saying the judge erred by finding there was a reinstatement of the loan, that he had no basis to make that finding, right?
Correct.
Okay. And my question is, what's our standard of review for that finding by the judge? And that goes to a question of what you agreed to as the process that the judge was going to follow. Because I've seen a couple of instances lately where the parties consent to a more abbreviated set of findings. You're telling us the agreement was that this was going to be essentially tried on the papers, right?
Yes.
No witnesses.
I mean, again, 90% of the matters have been taken care of by Judge Mitchell-Munivar on summary judgment. And prior to trial, myself and Attorney McGuire, we agreed, since this is entirely documentary, let's just submit on the documents. It was that. So Judge Mitchell-Munivar fashioned it as a question of fact, which obviously would have been clearly erroneous. But we submitted to Judge Del Puerto saying, well, let's acknowledge that the letter didn't go out. It's not whether the letter went out. It's, as I say in the brief, it's whether it should have gone out. And it only should have gone out if the loan had been reinstated and then defaulted again. Now, our position is the loan was reinstated. It was reinstated in 2014,
Okay.
defaulted in 2014.
So Judge
and
Del
then
Puerto determined that the 2016 document was a new contract, right?
paragraph 9 of his order states that, yes.
So it's a new contract, and that's because it had these two additional provisions.
No,
At
he
least.
relied primarily on the fact that he believed that Richard Zulli had been released.
Okay, so in addition, and not only that it had two additional provisions, but it doesn't have Richard Zulli as a signatory on the document.
The judge's order
What was
made no
error
reference.
about that finding?
The judge's order made no reference to those two additional provisions. I brought them up in trying to be honest with the court and saying this, rather than saying this is exactly like it, I said, well, it's exactly like it, but there's these two provisions. Judge Del Puerto didn't rely on that. He relied on the fact that he found that Richard had been discharged. Then the consideration made it far tougher on Brenda.
So he found that it was a new contract.
He found, yes, and I in my motion for clarification, I asked what new burdens, what new considerations, and he declined to examine that. He just went straight back to Richard having been discharged, and as I say, Richard couldn't have been discharged. There was no intent, there was no action, there was no striking of his name off the original note. Brenda was, and even if he had been, Brenda was already fully joint and severally liable, so this is an agreement that essentially did nothing.
Hang on.
It's not so much a question as a homework assignment. This January 10th, 2024 agreement on how you were going to do the trial, so it says here that you had an agreement with both parties in January 2024 that the judge approved to do the trial on the papers. Could you get that for us? Not necessarily right this second, but could you find that and send it into the court?
Yes, I will. I remember it exactly, that we both asked, we were scheduled for a trial coming up, and we both asked if we could do this. We didn't see the need to.
I'm not saying that was a mistake. It would be nice for us to see exactly what you said and the judge approved when we try to figure out the standard here.
I'll find that. Would you like me to submit that e-file as a separate document?
Just e-file it.
Thank you, Your Honor.
All right?
Thank you, Your Honor. I apologize for going over.
That's your time. Thank you.
Thank you.
All right, please.